Here we go. Oh, the slide worked. I'm so excited. Anyways, so first of all, I wanted to actually, I had a background slide, so I'll give you my background by itself to kind of give you more of a perspective where I'm coming from. So I started my career with Jane Campbell's administration at the city of Cleveland. And so I started in public sector work, and I was very blessed in working with a female leader. And so I talked to that because we are a women's group and we're very, so let's get started. So the Family's First Coronavirus Response Act was actually an expansion of FMLA. And what is FMLA? So many of you may never have had to deal with FMLA because of the fact that you work with smaller entities. So the Family Medical Leave Act was actually a concept of, you know, for 12 work weeks, you get unpaid leave in a 12-month time period. Okay, seems logical. And actually, it was created for pregnancy. It was originally put into place for mothers to be able to take care of their children. Actually has expanded not only from maternity, but also paternity, so that men can actually stay home with their newborns as well. And so that's why it's care for a newborn as well as birth of a child. It's supposed to be for adoption and foster care. So this is an act that is very specific. You have to get medical verification of actually having something that would be able to be eligible for. And these are all the eligibility reasons. A serious health condition is actually a harder standard to prove than you would think. It's not some kind of spike up or a sickness that you would normally get, like, I don't know, coronavirus. It's usually a serious health condition, a heart condition, diabetes, some kind of comorbidities we talked about, actually Roberta had talked about yesterday. So those are the kind of things that this is actually for. It also has an expansion on military. So these are some of the expansions that were already placed under the FMLA law. So you have to understand what the underlying law is first, to then understand the changes that were made to it in the last couple of weeks. So who is qualified under FMLA normally? This is before we talk about the coronavirus and COVID-19. Who is actually covered? So normally, private sector, 50 or more employees, all public agencies, and both public and private elementary and secondary schools. All right, so you're thinking to yourself, this doesn't pertain to me. Why am I even sitting here right now? Well, in actuality, it does pertain to you now once we go into the new expansions. The next is who can be an eligible employee. They had to have worked for a covered employer, so it has to be covered by that definition above. You have to have worked at least 12 months. You have to at least work 1,250 hours during the immediate preceding 12 months. And you have to work at a location for at least 50 employees within 75 miles. So this comes into play primarily when you are dealing with bigger entities that have locations in different locations. And so they may have like 10 people here and 15 people here, but guess what? You know, they have like 35 around the street. So then that would equate to a 50 person establishment. So what has changed? So the Family's First expansion happened about a month ago. It was the first act and change to be a reach out to the individuals that were affected by the coronavirus. And I think what the whole concept of it really was, and the intent behind it, was to reach out to employees. And the reason being is because of how it was written, how it expanded the FMLA. So you already said that there were certain standards in place and there were certain things that were in place. Now I'm going to show you how those certain things have been changed. First of all, 2 weeks, the biggest thing, the biggest change is you're taking an unpaid 12-week leave and making it paid. That's right, paid leave. which is something that is really seriously unheard of in FMLA ever. This is a huge expansion. This has been something that's been on the agenda from the Democratic Party for a really long time, but has never, ever come into play. Now you're taking a leave that was unpaid and you're forcing it upon employers. We're already going through some things as this whole thing's coming and unraveling, are now being forced to pay their employees in this certain situations. First of all, 2 weeks. So an employee is eligible for 2 weeks paid leave if they are quarantined or they're experiencing COVID-19 symptoms and seeking medical diagnosis. As you all know, testing was actually quite an issue at the beginning. That's why it was written as such, because a lot of people couldn't get access to testing to verify if they had or did not have COVID-19. So as an employer, you would have to pay your employee this. You have to pay them their full regular rate if they're being quarantined or for COVID-19 symptoms. Totally makes sense. But then it expanded further for those people not experiencing COVID-19 but are unable to work because of a bona fide need to care for an individual or care for a child under 18 whose school or child care provider is closed. So now things are getting a little bit more interesting. Now it's expanding. So again, FMLA has always been for a serious health condition, for a birth, or something very, very serious. Now you're opening and expanding this law to now incorporate some very interesting things that are, I'm going to say it, we hope are temporary. But here we go. Then they have the additional 10 weeks, again at 2/3. There are capped rates. I didn't go ahead and share those cap rates. If you're interested to know those, let me know. But up to additional 10 weeks, 2/3 regular rate if you're unable to work because of a bona fide need to care for a child during this whole entire thing. So you're like, okay, I'm still okay. This doesn't pertain to me. Unfortunately, it does. So what they did was they expanded FMLA to, that's right, all employers that have 500 or less employees. That's all of you. So every single person that's on the call that are possibly, business owners yourself, you have one employee, you are the only employee, you have other people that are just employees. This now pertains to you, which is really strange. There was a huge fight between the House and the Senate. So when this act went ahead and went through, this bill that became an act went through, there was a big dispute of whether or not 50 or below should come into play. The reason why they didn't go 500 and above, at least the reason they gave, was that for bigger organizations, they have a pretty huge volume of paid time off. And so the whole idea was that individuals could delve into those paid time off banks or sick banks or whatever that looked like for an employer. So it didn't affect that 500 and above. What's very interesting, if you go online and you start looking at how many people this really affects, there's a huge amount of employers that it doesn't affect with that 500 and above. So between the House and the Senate, they came up with this caveat that if small businesses with fewer than 50 employees are not exempt, but may qualify for exemption due to school closing and childcare unavailability, if would jeopardize the viability of business. Okay, so the viability of business is kind of what you want to think about. So what does that mean? That's a really good question, especially with the interwoven of the concept of the CARES Act, which we're going to talk about next. The CARES Act is supposed to help employers keep people on payroll, and now all of a sudden you're doing an exception that could kick you out of this concept. Nothing's really been kind of cleared up yet. I think this is going to become an issue, but I think just so you know, as a small business owner, when this concept comes to you, that you have something to kind of be able to fight. Okay, so also the eligibility of the employee completely dramatically changed. You heard that have to work there for 12 months. You have to have what, 1,250 hours. All that's blown apart for COVID-19. All you have to do to be eligible for the first 2 weeks is be an employee. That's it. And secondly, employees employed for at least 30 days are eligible for up to an additional 10 weeks of paid leave to care for their child under certain circumstances related to COVID-19. So you're saying, oh my goodness. So now this is affecting me as a business owner. I'm looking at my employees. So I don't know if some of you have people that have been affected by COVID-19. I have been blessed that I don't know somebody personally that I know of at this point, but I can really see this particular information to really come into play, especially with the governor's announcement yesterday that said point blank that kids aren't going back to school this year. So kids aren't going back to school this year, but we're all supposed to open up by May 1st. So there's a little bit of conflict there. And so will employees then claim this topic? That's a really good question. Also wanted to go into, you know, how you, different changes to the qualifiers. So, you know, as I said, the qualifications for FMLA was pretty stiff. It had to be a serious health condition. It had to be a birth of a child. Now you're opening things up pretty significantly. I mean, you don't even have to be technically diagnosed. You don't have to have medical documentation that you had COVID-19. You can just say that you have symptoms of COVID-19. There's no proof of those symptoms of COVID-19. And so it gets a little bit murky, or as I like to call gray in my area. And so you're starting to look at some of these qualifiers now that are a little bit more lax, to say the least, compared to your regular FMLA law that has been very serious and very specific on having medical documentation to prove things. So the medical documentation to prove things are not there. So keep that in mind. So now caring for an individual subject to an order or a self-quarantine. Am I taking care of my husband in self-quarantine right now? I don't know. Who's going to verify that? So this has become a little bit trickier in the employment space, especially when you're dealing with your employees and if they are actually asking for family medical leave. Okay, before we go into the next slide, are there any questions? And I didn't, actually, let's go on to Ohio unemployment and how it was affected by the CARES Act. So there's a lot of confusion in this area, but really taking it down to the root of it all is that this is the first expansion ever to affect independent contractors, self-employed individuals. And that is huge. Okay, I have never seen unemployment be expanded to me, you, everybody we're talking to right now. So as independent contractors and self-employed and business owners that you are, now you could be eligible for unemployment, and even part-timers. That's something that is not kind of heard of either. So part-timers that are losing their jobs, as long as they meet that $269 per week threshold, they can apply for unemployment. So this kind of explains why Ohio unemployment has expanded 200,000 people in what, a week and a half. Because Now, individuals that would never be able to claim unemployment can now claim unemployment. And here's the big question, where is that money coming from? So what's interesting on this is that I've been getting some phone calls from employers that are kind of odd ones, like, this person hasn't worked for me for a year. They resigned, so they wouldn't be eligible for unemployment, but why am I paying 40% of their unemployment? Good question. So I am dealing with those situations and appealing them because they shouldn't be. So unemployment, as you know, I hired about 300 people in the last like 2 weeks, and those individuals are just accepting claims. And so with this accepting, there's been a lot of misunderstanding on the opposite side of where that money is coming from. I'm gonna go ahead and take the, the magical Wizard of Oz, blinds off for a minute. And guess what? The employer pays for unemployment. It's not some magical governmental thing. The employer pays for this. They either pay for it in a premium or a dollar for dollar employer. Now, how does this work when I'm an independent contractor? Well, it's coming from that slush fund called the CARES Act for stimulus program. So that is one thing that was very huge. Second thing is unemployment was 26 weeks before all of this, and now it's been expanded to 39, which everybody's like, wow, that's so big. Well, you forget that it used to be 99 weeks. So unemployment in the first Obama administration was 99 weeks. Obama actually changed it to 26 or whatever the state. So there's different states have different weeks. They're primarily 26 weeks now, but it's only expanding 26 to 39. Will it expand again? Good question. As of right now, no. So the additional 6 weeks benefits. So I was talking to one of my friends yesterday, ironically, who's going through a bit of a transition. She's an attorney. And I said, what do you think about unemployment right now? And she's like, well, it's only $600. I do better just working like some contracting work. I go, okay, but that's not what that is. This is an additional $600 a week. So before we got started, Rochelle and I were yip-yapping back and forth. And what were we saying about that $600? That could actually, individuals could be earning more technically unemployed than employed. So they're getting their average calculated amount, which is usually between $100 to $535 a week. And they're having this add-on, and this add-on is $600. So the big question is twofold. One, where is the $600 coming from? Federal funding. So I laughingly say they're printing money. They are probably printing money right now on this one. And two, has anybody seen the $600 in their paychecks yet? No, but it is supposed to retro back. Also, this whole partial unemployment benefits is something that's very big with COVID-19. People are reducing hours significantly. And so they're taking somebody who's a full-time employee, dropping them down to what? 20 hours a week. And so that they are now eligible to file for unemployment because they have been seriously affected by COVID-19 because their hours have been slashed. And also the big question I also deal with a lot is, but my employer is furloughing me, which I love that term. They are furloughing me. They're keeping my health insurance. How does that affect my unemployment? It doesn't affect it at all. So the employer is being kind. They're keeping your insurance, but that's not going to affect your unemployment at all. Next. So wanted to make sure that you know that even though unemployment is being expanded in those ways, the criteria has not changed of unemployment. So unemployment is reserved for who? Layoff or furloughed individuals. 2, people that have been terminated for without just cause. And last, lack of work or reduction in force. In this case, it's due to COVID-19. So none of this criteria has changed. So big question, been getting it right and left, is this one: what if I'm scared to go to work because I think I'm going to get exposed to COVID-19 and I'm not going to work? Well, then you're not going to get unemployment. It's considered a resignation. Or I'm not going to show up. They can't make me come to work. I don't want to do this. I'm not going to do this. I'm going to go just file for unemployment. I'm going to make more on unemployment. Well, guess what? That's called job abandonment. You're not going to get unemployment. You know what? This has been a stressful time. I'm really getting mad about my boss. They're really not making me happy right now. Well, guess what? You start screaming at your boss, it's insubordination. You're going to be terminated. That's just cause. Guess what? No unemployment for you. So I have had the luxury, I'm going to say the luxury of being able to help people on both sides. And I've been able to guide people to correctly leave their employer in the best possible way as possible for them, and to not get terminated for just cause in the process, so they don't give up their unemployment rights. So if anybody knows me, I say a couple of things. One, don't sign anything. Two, don't resign. So that gives up any of your rights for unemployment. So I think I did see a couple of questions kind of pop up, and I can't bring them up right now. So please unmute yourself and ask some questions. So the CARES Act. So I didn't want to, I'd be remiss if I didn't go into what the CARES Act is actually doing, and I do have limited time, but I did want to share with you some of the financial assistance that's out there as business owners and individuals. First of all, I wanted to explain the recovery rebate. And so it kind of gives you a better understanding of what this is, because everybody's talking about this $1,200 check we're all getting in the mail, and why haven't we gotten it yet? And this is what it actually is. It's a question if you will even be eligible for it. So individuals are up to $1,200 if they're less than $75,000 a year, and they're looking at last year's tax records to come into play on this. If you are actually making more than that, if you hit that $99,000 a year, then you are not eligible for anything up above. So $100,000, you get nothing. Be aware of that. And then couples, you can make up to 150. You can get that 2,400, and then you get an additional 500 for your children. But this can all be kind of skewed based on what your tax records look like from last year. So that's what they're basing this on. So this is the check that's in the mail. This is what the reality of it is. You may get different parts of it. This is not something you have to apply for. This is all based on your tax records. The second is the EIDL. It's something that I know I applied for. It's an advancement of $10,000 a company, but it is also pertains to how many employees you have. So if you have less than 10, then you're not going to get 10,000. So if you have 2 employees, you'll get 2,000. So that's how it's kind of on a grading scale. I highly recommend you talking to your financial advisor, your accountant, to kind of see how to apply. And everybody's like, but I don't think there's any money in any of this yet anymore. I'm like, well, guess what? There is money. They are looking at refunding the PPP, which is the other one that I want to talk about, is the Paycheck Protection Program. This is another one that you can apply for as a small business owner. They go ahead and they forgive these loans if you meet certain criteria. So the whole idea of PPP is to keep your employees employed. They don't want everybody to go and run to unemployment. This was the whole concept of, I'm going to help small business owners keep their employees, and we're going to do this by giving them a business loan that they don't have to pay back. Again, federal funding limits is coming into play because anybody who has been following the lovely internet and everything else right now, you are seeing some issues with this not being funded anymore. Guess what? You're seeing Congress come up with, that's right, trillions of dollars more. So definitely, if you meet these criteria, this is something that you want to look towards to help. And this is, the PPP is really for payroll, your mortgage, your rent, your utilities. Now with the 90 days that they cannot go ahead and foreclose on commercial real estate, that was just enacted by our governor last week, that they can't evict you from your space from working. So keep that in mind too. I'm seeing everything kind of blow up. Let me go ahead and get through the next one. I did want to come up and tell you about litigation avoidance for small businesses. The reason being is because litigation is going to be rampant after all of this kind of comes to a close. And what I wanted to share with you are some of the cases that are out there right now, some of the areas that they think that will really explode. And, you know, I've definitely reconnected with my alumni association and with the Cleveland Metro Bar Association, and they're seeing the exact same thing. So the workplace safety concerns with OSHA. So they're seeing that there may be OSHA violations if employers don't have the correct protection equipment. So that's kind of going to come into play when people return to work. That's going to be a big thing. American Disabilities Act discrimination. So they're saying that there are going to be some serious repercussions from COVID-19, meaning that individuals that do survive COVID-19 may have some kind of disability from it because it is actually harming the lungs. It also is causing heart disease. And so they are worried that there may be some kind of discrimination connected with those people that have already been exposed and have survived it, may have some kind of underlying disability from it. FMLA, I've already shared with you extensively the violations that you can see that are going to come up because of all the different changes from the Family First Act. Personal injury, there are no car accidents now because people are not on the road. And so personal injury attorneys have been available. What does that mean? That means they have time on their hands and they're looking at negligence as being a big thing. And they're saying specifically that as the employer, you promoted the spread of it, you also hid information about the risks. Breach of contract, event cancellation, service disruption, you name it, landlord, tenant, vendor obligations, all of your contracts have blown up right now because guess what? People aren't paying their bills. So you're going to see a lot of different breach of contract aspects of things, especially since everything has been closed down. Good news is the courts are not open to non-emergency cases until June 30th. But bad news is all the statute of limitations have been told, which means told, T-O-L-L-E-D, told. I can say that fast. They have been told so that people can go ahead and file against you when everything opens again. Isn't that great? Yeah, so exciting. So protect your business is your big thing. Return to work plans are huge right now. Make sure you follow your guidelines so you're not seen as a negligent employer. Drafting new policies and procedures with the 2 acts that are in place and any other future ones because, you know, times are changing every week. And consult with your advisors. And there I go. Look at that cute picture. Oh, with short hair that I don't have anymore. So I didn't get the last questions on the CARES Act, so if you can share those with me.